Also breaking tonight, the Illinois Supreme Court rules a controversial part of the SAFE-T Act can take effect statewide this fall.
The decision will make Illinois the first state in the nation to do away with cash bail. WGN's Dana Rebick is here with reaction. Dana.
Well, this was a 5-2 decision that was split right along party lines. The state Supreme Court upholding a portion of the SAFE-T Act, ruling that eliminating cash bail for defendants awaiting trial does not violate the Illinois Constitution.
I'm here for a retail theft, under $300. I'm in here because I don't have any money. I am poor. I don't have any money to pay my bond.
The Cook County Jail, one of the most crowded in the country, when we visited back in 2016.
They were being held because they couldn't come up with $100.
Stories of inmates charged with nonviolent crimes, some held here for years awaiting trial.
That's just been the norm for hundreds of years in this state, and those are just heartbreaking cases.
I feel like we're on the right side of history.
Cook County State's Attorney Kim Fox applauding the state Supreme Court decision today, which will eliminate cash bail in Illinois effective September 18th.
What I am celebrating is a system that is designed to keep our community safe, where people who are a danger to the public don't get to get out simply because they have access to cash, and people who are not a threat to the public are not incarcerated because they are poor.
The SAFE-T Act passed in 2021, but the bail portion of the law, the Pretrial Fairness Act, was supposed to take effect on January 1st. It was delayed after a Kankakee County judge found the measures unconstitutional after a coalition of state's attorneys and sheriffs filed a lawsuit against it. That lower court ruling now overturned in this landmark decision, making Illinois the first state in the country to eliminate cash bail entirely. Now judges must weigh if a defendant is a danger to the public or a flight risk in determining pretrial release. Some states' attorneys are still concerned about certain Class 4 felonies.
Unfortunately, there are still some offenses, burglary being one of them. Unless there's injury to a person during the course of the burglary, judges will not have the ability to detain people for burglary if they find that they're a threat to the community.
Others feel this paves the way to make jails a home for the dangerous, not the destitute.
I think you'll see other states who've watched Illinois' growing pains, who've seen the political battles as well as the legal battles, take the momentum and do the right thing.
And Governor J.B. Pritzker saying today we can now move forward with historic reform to ensure pretrial detainment is determined by the danger an individual poses to the community instead of their ability to pay their way out of jail. 58 of the 102 state's attorneys in Illinois opposed this law. The Chief Justice in her decision said that the Constitution does not mandate that monetary bail is the only means to ensure criminal defendants appear for trial or the only means to protect the public. Now, defendants currently being held because they couldn't pay their bond, they can start to petition to try to get out and be released starting September 18th.
And this was a big issue during the governor's race, so
It
not
was.
everybody's happy today.
It was very politicized for sure.
All right, thank you.
Yep.